Alfredo Campos, is this a plea?
Yes, Your Honor.
All right, can I have a file stamp for a plea, please? Court is calling 2025 CR 002720 State versus Alfredo Campos. Could I have parties announced?
Mayor for the state of Texas. Renee Munoz on behalf of Mr. Campos.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Is there an application?
No, Your Honor.
All right. Mr. Campos, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, so proceeding. Additionally, Your Honor, state will waive the repeat offender enhancement. Also no objection.
Okay. All right. Did you review the document entitled court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right. In count 2, you're charged with assault family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is proceeding on count 2. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor. I did mention that when you get to the stipulations.
All right. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
And you're not allowed to be designated as a primary custodial parent?
Yes, sir.
All right. Knowing that, do you still wish to continue with this plea?
Yes.
All right. Did you review the waiver of repeal paragraph with your attorney?
Yes, sir.
Did you understand it and sign it in both places? Did you understand it and sign it
Yes.
in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Judge.
Then to the offenses charge, how do you plea in count 2? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, this time state orders into evidence, states exhibit 1 with all attachments. No objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking the court follow the negotiated plea bargain agreement, Your Honor.
All right. So what is wrong with you? This is a person, for whatever reason, decided to pick you up from custody when maybe she should just let you stay in there, for whatever, and let you just stay there. She takes it upon herself, and I'm sure she paid your bond, and she picks you up and brings you back home, and then you beat her up. What's your issue?
I have an issue.
Yeah, I mean, you do. Because somebody who, do you love her or do you claim to love her?
No.
No, you don't, because that's not the way you treat people you love. She took it, probably money from her children to pay to bond you out. And then, all right, let me tell you what's in the police report and you tell me what's incorrect about this. I asked victim what happened. Victim stated the following events occurred. Since Wednesday, she went to pick you up from the jail. She stated they were good, no problems. Later that day is when the defendant began to strike and choke the victim. So this is where we are.
I don't know if, I think he just got a little bit tangled up. I don't know if he bonded out or if he was just released at that point and then she picked him up instead of the bond. I think that's where he was a little confused.
I was just confused because I was released from ISF, not from the county jail.
Oh, okay, so there was no bond posted. Okay, that's what I think he.
So here's my question. Is the reason for this offer because the complainant does not want to participate and has filed an affidavit of non-prosecution? All right. So she's filed an affidavit of non-prosecution, even though I'm looking at the photos. She has a black eye, she has bruises on her arms, and she took time out of her busy schedule to come pick you up from wherever you're incarcerated. So for some reason, she's attached herself to you, but I'm going to try to break that cycle today. So I'm going to sentence you to 3 years in prison. There'll be credit for any time served. There's a $1,500 fine. Time and money is not running concurrently. There's an affirmative finding of family violence. There's to be no contact with Ana Maria Hermio, aka Ana Maria Gonzalez, and you're not allowed to reside in any residence with minors. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed this plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. We can go off the record. Here's the thing. Don't get involved in any other relationship. Don't contact her. If you love her, the best thing you can do for her is not contact her, because you're not any good for her. And until you figure out why you feel the need to put your hands on people in anger, you should not be in anybody's relationship. Here's my advice to you. Get an orchid. I always tell people that, and this is why I tell people to get an orchid. An orchid takes a lot of patience. When you get it from the store, it's beautiful. They all have them all with the flowers bloomed on it. They will give you directions. Those directions don't work. I learned you're not supposed to put ice cubes in them. But if you can let the blooms fall off of that orchid and keep that same orchid and get it to rebloom, you may be ready for a relationship, because with orchids, you have to learn patience. You understand? Court is calling 2022 CR 3597, State of Texas versus Chardonnay Leanne Lockhart. Can I have parties announced for the record for the state? Defense.
Andrew Frederick, Ms. Lockhart.
Are you Miss Lockhart?
Yes.
Right. Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lockhart, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
I am a female. You keep saying, yes, sir.
No, I said yes, Your Honor.
No, you said, yes, sir.
I said yes, Your Honor.
I would
Okay.
say, I heard yes, Your Honor, as well, Judge.
Okay. All right. Are you proceeding on
I
the,
have one moment.
indictment as presented?
Judge, we're going to go with the lesser included offense of attempted arson, recklessly causing damage.
Okay. Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right. Oh, you're right. She did say yes, Your Honor. I don't know why it sounded like sir. And my allergies are really, I apologize. My allergies are really acting up today.
And Judge, I whispered to her that she needed to speak up and not say it, so she know.
Okay, that's okay.
Thank you, Your Honor.
Because sometimes people always say that. And I'm like, what? All right. Did you understand the state is proceeding on the lesser included offense of attempted arson recklessly causing damage as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Actually, Judge,
I believe, Judge, since it's attempted, the arson recklessly causing damage is a state jail, and since it's attempted, it's a Class A misdemeanor.
Okay, why do you guys have this filled out as a state jail?
It should have been
the
changed.
first paragraph specifically should list it as a Class A.
All right, so you all need to redo this piece of paperwork.
Sure.
And I would suggest that you use the felony paperwork. That way you can write it in, because otherwise
It's difficult.
I don't have knowledge that she knows that it's a Class A, because that's not how it's listed.
That first paragraph I wrote A right next to it. That's my handwriting. First page, Judge, it says range of punishment, and it listed up to a $4,000 fine and up to a year in jail.
Oh, okay, you are correct. Look at
Every
this.
once in a while, Judge.
Corrections are happening. I appreciate it.
I hate to correct you, Your Honor.
No. Here's the thing. I always tell people,
Sounds good.
make sure that if I'm saying something that's incorrect, to let me know. Okay?
That's what we did there.
All right. So this is what I'm going to need you all to do, though.
Yes,
I
Judge.
need her to initial it so I know that she knows, because all of this is state jail felony paperwork. That's why I say state jail.
Sorry about that, Judge. I saw that. I thought about using the other paperwork, but I didn't know if that was probably the better way. From now on, I'll probably try and do that.
Okay. Because all this paperwork is state jail felony paperwork.
I tried crossing out, it was the felony, the discussion about the felony, with the felony in possession of a firearm. And I thought I caught everything else. I think I changed everything to reflect
Yeah,
it.
we
Okay.
erased all of the stuff about the firearm possession because that doesn't apply because it's not a felony.
Okay. Let me carefully read through the paperwork. Just give me a moment to make sure that everything is the way it should be. All right. All right. So we're back on the record. All right. They're charging you as arson as a Class A misdemeanor. The range of punishment for that offense is up to $4,000 fine and up to a year in the Bear County Jail. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court only has the authority to sentence you up to 1 year in the Bear County Jail and up to a $4,000 fine?
Yes, Your Honor.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
If I could answer a little bit more, Your Honor. Yes, I do believe she does. She's mentally competent. She was done a psych evaluation for competency a few months ago. She has been found competent after discussing the case with her today and last week as a jail visit. I agree, she is competent.
All right. So she's already been to the magistrate's court and they've deemed her competent?
That's correct, Your Honor.
All right. Do you believe she was sane at the time of the offense?
Yes, Your Honor.
Ms. Lockhart, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
All right. The court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Okay, according to the plea, the state is proceeding on the lesser included offense of attempted arson recklessly causing damage. They're recommending deferred adjudication. They're taking in consideration County Court Cause number 634806, and there's to be a MIC evaluation. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There you are.
Next, I'm showing you outside the plea bargain agreement. State is recommending that your deferred adjudication be for a term of 2 years and there be a TAP evaluation. Did you understand?
Yes, Your Honor.
Okay. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
All right. Then to the offense of attempted arson recklessly causing damage, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer state exhibit 1 in all attachments.
No objections.
Right. I'm going to show you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yeah.
All right, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
That's to follow the plea bargain.
All right, Ms. Lockhart, if you're released from custody, do you have a place to live?
Yes, Your Honor.
Where?
738 Morris.
No, I'm sorry, don't say the address,
Oh,
but who will you be living with?
I apologize. It's a property my father had bought me.
Sorry, what?
I'll be living by myself.
Well, whose property is it?
My father.
Why were you not living with your father before? During this incident?
No, it's because I'm 30 years old.
Well, no, here's the thing. I'm reading this and it appears, rightly or wrongly, the way I'm reading it, it appears that you were homeless. It says that you started this fire because you were trying to dry a blanket. So I'm wondering why you were not living. Well, no, that's what they say you told them. It's in the police report. So I'm trying to figure out why were you homeless and why would your father let you live with him now?
Judge, if I can just have a second.
Here's the thing, Ms. Lockhart, you need to be honest with me because I'm trying to figure out your conditions. And let me just tell you, one or two things are going to end up happening. If I don't believe you're going to be honest with me, this is going to be set for a PSI. You're going to be sent back to the Bear County Jail. They're going to do a PSI report and I'll get it when I get it, which will probably be within 8 weeks. So you need to answer my questions and you need to answer my questions honestly. Now, in this police report, basically it's implying that you were homeless because it said there were clothing and other items and that you lit this fire because you told them you were trying to dry your blanket. So this is what you stipulated to. I didn't force anybody to stipulate to it. That's what's in the police report. So why were you homeless if now you can live with your father?
I wasn't at home, but I was not homeless.
So why were you living in this field or wherever it was with your items?
I have no idea. I don't know how to answer that.
All right. So why is she wearing yellow today?
I'm pregnant,
Okay. I just wanted to hear it. And how far along?
like 21, 22 weeks now.
Judge, I didn't mean to be presumptuous, but I have been in this court once or twice before. I did tell her she was going to be taking a parenting class, which was theoretically outside. But she understands she's going to take the parenting class going forward because that's going to be her.
All right. And is she on medications at the jail?
Yes, Judge. She was not on her medication at the time. Now she is on her medication. She's frankly alive. She's definitely competent at this point in time. At the time, she was not being rational, but at this time, she is going to be successful going forward. There is the part about the mental MIC caseload and her being interviewed for that. I believe that would be necessary. And she understands that being med compliant is going to be a part of that as well.
All right. Do you have any other children?
Yes, I do.
How many?
2.
And where are they?
Out of town with my family.
And what are their ages?
11.
They're both 11, twins?
Mhm.
That's either yes or no.
Yes.
All right. This is what, is there anything else from either side? Do you know if she's receiving SSI now?
I don't know.
All right. I'm going to sentence you to 2 years deferred adjudication. I'm going to want felony drug court referral. They should be able to do it because it's 2 years. And I'm going to want a MIC evaluation. Those are to take place while in custody. And then I'm going to want a referral. If she's not approved to MIC, I want a referral to Center for Healthcare Services, parenting classes. Take in consideration County Court Cause number 634806. 80 hours of community service restitution. Once she completes parenting, that will be satisfied. Regular reporting by Zoom or in person. Regular UAs. And I'm going to want a TAP evaluation in custody as well. If TAP recommends inpatient treatment, we'll start her with intensive outpatient treatment. And I'm going to want field visits 1 time per month until further notice. Probation will do proof of employment within 30 days of release or proof of SSI within 30 days. There's to be no employment as a home health care provider or with minors. And I'm sorry, instead of the regular UA's probation, I'm going to want the UA hotline with testing at least once a week. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, Your Honor.
Counsel, do you think there's anything else your client needs?
There's nothing else she needs, Judge. We asked that the evaluations be done when she's out in custody.
All right, that will be denied. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, yes,
All right,
sir.
because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Right, yes, Your Honor.
All right, we can go off the record. Was she not approved for mental health court?
Honestly, can't tell you off the top of my head, Judge. Since she's been in custody this time,
Mhm.
we've conferred with the DA, and this is the attempt. She's